So you had asked a very pertinent question, how much time have flown after the IPC, CRPC and Indian Evidence Act came into existence. I was just making a calculation. The IPC is 163 years old. And the Indian Evidence Act is 130 years old. And if we calculate 1972 as the promulgation of CRPC, though it was there earlier, so it is already 51 years old. But all these three acts, which is going to be repealed today, are the acts of 19th century and 20th century. We are in 21st century. So I would say 4 months ago, after the first introduction of 3 new pieces of legislation to overhaul the criminal justice system, the government, Honorable Minister for Home Affairs, placed it before us and revised it last week. The new criminal code makes some crucial changes. The bills for the first time bring terrorism, corruption, and organized crime under the ambit of ordinary criminal law. There were special laws earlier, but now it has come into the ordinary criminal law. These aspects were reserved for stringent special legislation since they upend the general protection by reversing the burden of proof on the accused, as per French jurisprudence, to restrict bail. At the time of introduction, the government had told us that 3 provisions of IPC, that is sedition, criminalization of homosexuality, and adultery, been repealed. Fine print shows Rajdroha being changed to Deshdroha. The narrative has been doing the rounds for quite some time that the Indian criminal justice system is not delivering. Victims of crime are often helpless. The cases are dragging endlessly and courts are getting choked. These are the 4 major issues which actually were perturbing us for quite some time. All this is being caused, it is said, because of colonial laws that somehow do not fit with Indian traditions, Indian customs. The magnificent edifice of the democratic structure today in India rests on the rule of law. As it is always said, as the civilization progressed, the society formed a ruler or created a Raja. But Raja has to perform his duty through law. It is not actually the Raja who protects the subjects. It is the law which protects the subject. That is the reason why we look up to our Constitution with great hope and admiration. Because it is not the people who are prime ministers or chief justices. They don't give us justice. It is the law which protects every citizen of this country. It may be said the state does not protect the citizens. It is the law that protects the citizens. The law is supreme. The 3 bills that are before us today is replacing laws of 19th and 20th century. The question is whether they reflect current norms, of criminal jurisprudence. Numerous facets of Indian criminal justice system predate its independence from the British. The IPC was modelled after the Irish Penal Code made by English rulers that came into effect in 1860, though the Commission was formed in 1838 and took 20 years to frame the provisions of the Penal Code, and subsequently it got implemented in Ireland, but subsequently in India it got implemented in 1860. First enacted in 1861 and revised in 1973, The CRPC establishes rules for criminal proceedings. In 1872, the Indian Evidence Act, which was modelled as per the British jurisprudence, was passed. Since 1872, this has not undergone any significant changes, and now it is going to be changed with the approval of this House. Invariably, there have been some talk in media and also outside that how can we pronounce these Hindi versions of the law, Bharatiya Nyaya Sanhita. As Indians are very innovative, they have already found a way out. Instead of saying Bharatiya Nyaya Sanhita, lawyers are also saying BNS. So in that respect, that is not an issue in some quarters where they have a tendency not to utter Hindi names or Indian names. BNS is going to be primarily a primary legislation governing criminal offences. This bill preserves several sections of IPC. Additional changes include the implementation of new laws targeting organized crime and terrorism. Strengthening of punishment for certain existing offences is made and introduces community service as a form of punishment for some minor offences. Importantly, excluded from consideration are specific violations under IPC that have been invalidated or modified by judicial rulings. These include acts of adultery and same-sex intercourse and stipulated in section 377. BNS will have 365 sections instead of 511 sections. 175 sections have been changed, 8 new sections been added, and 27 sections been repealed. Now, I would come to 3 or 4 specific sections of BNS, Bharatiya Nyaya Sanhita. Now, IPC section 124A, that is sedition. Words spoken or written or by signs attempt to infuse hatred or contempt or excites or attempts to excite disaffection towards the government established by law, unquote, be punished. That is the sum total as sedition has been described. And large number of freedom fighters, including my parents, were all imprisoned because of this section and went behind bars for months and years together. But section 150 of the BNS 2023 says, and I quote, or by electronic communication or by use of financial means excites or attempts to excite secession or armed rebellion or subversive activities or encourages feeling of separatist activities or endangers sovereignty or unity and integrity of India be punished. Instead of government, as I said earlier, established by law, the new section says endangers the sovereignty, unity and integrity of India. This is a very welcome step. But I find still some loopholes which need to be plugged. Instead of making incitement to violence or disruption to public order a condition precedent to invoke the charges, the proposed section 150 continues to criminalize any act that excites or attempts to excite secessionist activities or encourages feelings of separatist activities. Furthermore, penalizes a person who indulges in or commits any such act, thereby casting with the law enforcement agencies a greater discretion to decide what can be brought within the fold of an act endangering some sovereignty, unity and integrity of India for slapping the charges. This discrimination needs to be, I believe, this can be looked into, and it gives a very wide spectrum of discretion to the enforcing agencies. Thirdly, the term separatist activities can be interpreted in several ways. and can be used as a political tool to curb opposition parties who organize protests against any of the policies tabled by the government. Then 153B of IPC have been recast as Clause 195 of BNS, with an addition where 195(1) subclause D criminalizes the making or publication of false and misleading information jeopardizing the sovereignty, unity and integrity or security of India. The phrasing of Clause 195(1)D raises three potential causes for concern. False and misleading and jeopardizing, these are two words, renders the clause very vague. There is need of clarity. It leads to multiple interpretation. Similarly, the word jeopardizes can cover a wide, unforeseeable range of consequences. Why leave all this in the hands of discretionary decision makers? It should be noted that criminal law does indeed deal with the matter of determining what constitutes false information. It also does in other situations, such as making a false statement under oath or providing fraudulent evidence. But in this clause, due to subjective nature of determining truth or falsehood, despite the need to control the mass dissemination of misleading information, will become very challenging. Another issue which has been incorporated in BS is organized crime. Clause 109 and 1010 been introduced effectively to deal with organized crime. Clause 109 borrows heavily from the existing state legislations in organized crime, especially from Gujarat and from Maharashtra. That is also necessary. Clause 110 creates a separate category of petty organized crime from organized crime for the first time. In IPC section 120A deals with criminal conspiracy where two or more persons agree to commit a crime. Two things, gang criminality and racketeering have not been defined. So also anchor points. There is a word in the bill, anchor points. I fail to understand what it meant. There is no distinction between the commission of an offense and its attempt. So there is, it has to be, I think, needs to be looked into. Then concept of community service is not there in IPC. This is a welcome step, but BNS does not define what community service will entail and how it will be administered. On mob lynching, clause 101, subclause 2 and 115, subclause 4 introduces new provision against heinous crime of mob lynching without specifically using the term. Section 352 IPC is applied for murder. It says whoever commits murder shall be punished with death. The BNS, there is a phrase, personal belief or any other ground which is without any definitional clarity. Therefore, it is quite dangerous. On abortion, section 132 of IPC is there. Unfortunately, except for moving the provisions from section 312 and up to 316 to clause 86 to 90, no significant changes have been made. BNS does not even bother to change arcane terms such as quick with child with an appropriate word. There are certain other words also relating to a cart, relating to a horse. All these things have been there that needs to be removed because those were the idea of 19th century and most of them have crept in here. It repeats language that was in the 19th century. Medical and ethical understanding of pregnancy and abortion has undergone tremendous change in today's world that could have been brought into our in this BNS. Now coming to BNSS, This will replace CRPC 1973. And the major issue is here, audio-video recording is now made in line with the increasing use of technology and by ensuring greater accountability and transparency in police investigation. Courts have time and again emphasized the need for utilization of audio-video recording. Clause 105 in BNNS is new, which aims to record search and seizure through audio-video electronic means, preferably cell phone. Instead of Section 157 of CRPC, it is Clause 176 relating to procedure for investigation. Proviso is added in the BNSS, which was absent in CRPC. However, Section 161 and Section 154 been retained in Clause 180 and Clause 173 of BNSS. Subclause 3 mandates for videography of the process of forensic evidence on mobile phone or any other electronic device, which is a safeguard against manipulation and irregularities. This is crucial safeguard to prevent torture and coercion of the accused during questioning in custody. But a significant drawback is that this is not mandatory requirement. It is certain whether subsequent recovery evidence need to be recorded audio-video wise is not mentioned. There is no mention of audio-video recording during investigation like spot inspection. Instead of Section 164 of CRPC, under 183 of BNSS, recording of confessions and statements before a magistrate is crucial safeguard to preserve the rights of witness. Confession be recorded in the presence of a lawyer, which is all-important safeguard against false confession. But this should have been made mandatory. The provision under Section 321 of CRPC has a gap in terms of allowing the prosecutor to withdraw from the prosecution of a case with the consent of the court without giving the victim a chance to be heard. But this is addressed in Clause 360, allowing that the victim must be heard before such withdrawal is allowed. This is a significant step. The right to information for the victim has been expanded in BNSS. So in that respect, I believe BNSS has expanded the scope in protecting the victim in a very great way. One issue is relating to handcuffing. It falls short of well-settled constitutional threshold established to protect a person's right to dignity under Article 21. Only thing has come, economic offenders are now being exempted from handcuffing. Clause 398 is an entirely new addition, which provides every state government shall prepare and notify a witness protection scheme for the state with a view to ensuring protection of the witness. This is a welcome step, no doubt, but it merely reiterates the direction under Mahendra Chawla case, nothing more. Clause 173(6), 173 subclause 3 introduces a mandate for the collection of forensic evidence by the forensic experts in all offences punishable by imprisonment of 7 or more years. This clause broadens the scope of forensic experts, which could include private experts without any regulatory body to ensure their proficiency or compliance with professional and ethical standards that could lead to problems. As we have institutes now in our country where boys and girls are studying forensic science, I think this scope is going to expand in a very great way. But we need we need a regulatory body also to look into that. Article 22 of the Constitution requires a person in police custody to be produced before a judicial magistrate within 24 hours. The CRPC provides this. The BNSS retains this provision. There is a phrase, occasion is past. This was not defined, but subsequently after the Standing Committee gave its report, there has been change in that. BNS specifies in petty cases, person be released as soon as possible within 24 hours. But it leaves a lot of things for the enforcing agency to their discretion. A demonstration, I have participated. Police catch hold of me, takes me to a certain place, and takes me 25 kilometers, 25 kilometers away in a jungle and leaves me there. What can I say? I can only travel by foot and come back and say, yes, I have come back within 24 hours. But that's not the case. It happens. It happens with all political demonstrations. Now come to the last point, sir, last bill, that is Bharatiya Sakshya bill, BSB. The Indian Evidence Act 1872 provides two kinds of evidence, documentary and oral evidence. The bill provides that electronic or digital records will have the same legal effect as paper record. There is a need to reset the justice dispensation system. Appellate courts are overburdened with appeals. Victims waiting for years and under trial prisoners languishing in jail beyond their presumed conviction time. The policing system has not embraced the advancement of 21st century technology that has transformed investigation and criminology in other countries. Indian Evidence Act of 1872, sir, is a relic of the past. And we have discussed this aspect a number of times in this house earlier. The bill exhibits modern modifications, linguistic adjustments for gender, inclusivity and replacement of outdated terms such as insanity with mental illness. In the bill, the definition of documents has been expanded to include electronic or digital records on emails, server, logs, documents on computers, laptop or smartphone, messages, websites, locational evidences, and voicemail messages stored on digital devices. The definition of evidence has been expanded to include any information given electronically which will enable the appearance of witnesses, accused, experts, and victims through electronic means. The BSB has incorporated most of the recommendations made by the Standing Committee on Home Affairs. Several drafting errors that were highlighted have been also addressed. Under the Indian Evidence Act, information received from an accused in police custody is admissible if it relates to a fact discovered, whereas similar information is not admissible if it was received from an accused outside police custody. The BSB retains this distinction. In 1960, I'm coming to the point why I'm mentioning it. In 1960, sir, the constitutionality of this provision was challenged on the ground that it creates an unjustifiable discrimination between persons in and outside custody. The Law Commission in 2003 suggested redrafting the provision to ensure that information relating to facts should be relevant, whether the statement was given in or outside police custody. The Law Commission has made several recommendations which have not been incorporated, but overall, the BSP is in tune of time. Relating to, because this is also being discussed outside, I think some members may also be speaking on that aspect. If I give a statement before a police, I may be under duress. And this has been pronounced by the court that it's not admissible. If it is given before a magistrate, one thing has happened that before a lawyer also it can be recorded, as it is happening in some modern countries or some advanced countries. To a certain extent, the accused needs protection, especially from the law enforcing agency. That needs to be. In conclusion, sir, I may say laws introduced during the colonial era were enacted to keep the subjects, praja, as we say, the subjects that are the Indians in a line. Therefore, it is imperative that the outlook must be changed and law and order must be viewed outside the colonial lens. Since the drafting of new criminal law is in discussion, it is imperative that justice prevails, as drafting criminal law of a nation is not a regular practice. Sir, this reminds me of one thing that we are missing here in this house. It's for your consideration, sir. In the old house of present Samvidhan Sadan, there was a line on top of your chair. Dharma Chakra Pravartanaya. Wheel of righteousness shall prevail. Sanskrit mein Dharma Chakra Pravartanaya. What we do here, what we discuss here, ultimately it is the Dharma Chakra that we are pravartaning. So in that respect, you can find a suitable place. You can find a suitable place because that is something unique of our culture, our civilization, that can be considered. And here, history is in the making today. That new law for our criminal jurisprudence, our Indian criminal jurisprudence is being enacted. That's a great thing that is happening. And I personally thank our Home Minister for taking, and also the Prime Minister, for taking the initiative. Others could have done it, but they couldn't. They didn't. And you have taken that challenge upon yourself, and the government has taken that challenge upon itself. It is our credit that we are witness to this history in making. Thank you, sir.
Vishnu Dayal